So welcome everybody to our second session of this year of the workshop series on the social analysis of penalty across boundaries that is organized by the program Crime and Society of the National University of Litoral in Argentina and the Scottish Centre for Crime and Justice Research. We are very, very happy to have today to make her presentation Mary Rogan. Mary is professor at the Trinity College in Dublin, and she has been working quite a lot on different issues in relation to prisons and punishment. Particularly, she has done a lot of stuff related with prison monitoring and inspection and on pretrial detention. And she will present today a paper related with this second topic. The title is Bail, Pretrial Detention, Comparing Legal Systems and Legal Cultures. That is, I think, connected with a new book that it's about to be published. So Mary, many thanks for being here. So the floor is yours. You have something like 25-30 minutes, and then we will do a Q&A.
Great. Thank you so much, Maximo, and thank you to you and to Richard for the very kind invitation to be part of this series. I'm really delighted to be here. It's always wonderful to renew connections with our cousins in Scotland and to make new connections elsewhere. And thanks to all at the SCCJR for all the work that you do. So I'm going to speak today about some work I've been doing with others on the topic of pretrial detention. The paper is based on a study from a few years back now called the Detour study, which was an exploration of how pretrial detention is used and the decision-making processes around the use of detention at the pretrial stage in 7 EU countries, including Ireland. And arising out of that, and with a lot of work in between, myself, Christina Morgenstern from Free University Berlin and Walter Hammerschmidt from Austria, we have put together an edited collection exploring the influences on decision-making in pretrial detention across those 7 EU countries and also including now the UK. So I'm very happy to talk about the case of Ireland here and to share some reflections on what features of the Irish approach to pretrial detention might be unique, what ones are shared elsewhere, and what those things might say about how pretrial detention is used and the influences on the decision-making process around detention at the pretrial stage. I'm going to focus a bit on judicial culture and legal culture more generally surrounding the use of pretrial detention. And I'm using the Friedman definition of legal culture: values, opinions, attitudes, and beliefs about law. Ireland is, as we'll see in a moment from the graphic, is a comparatively low case of pretrial detention in European terms. And a number of things are driving that, but two large factors, I think, are the legal framework, which is taken seriously and which is very much an influential factor in decision-making processes. That legal framework tends to emphasize alternatives to pretrial detention and uses alternatives as kind of a default position at the pretrial stage. And then aspects of legal practice, so particular elements of our legal culture which seem to take this idea that bail or an alternative to pretrial detention is a sort of default position. Now, as you'll see, that's coming under threat, but historically, that's certainly been the case from the research that we've done here. That legal and judicial culture is different to the one we discovered or discerned or explored in the other European states that were part of this study. It's shared with some other places, notably England and Wales, with some differences, of course, but the elements of that legal culture and judicial culture have something to say, I think, more broadly about the influences driving the use of pretrial decision making. And at the outset, I want to make a comment about the term bail. And this in itself, I think, was quite a revealing early starting point for our comparative discussions in the original Detour project. it's not natural for me to use the term pretrial detention. The term, when we're talking about what happens at the pretrial stage in terms of the use of custody or otherwise, the overarching term and the primary term used is that of bail. And that's the case in some other places too, but it's not the case elsewhere. And bail, when I'm using the term bail, I'm using it to refer to the concept that the alternative, the single alternative to pretrial detention that may have multiple conditions attached to it, but bail is the alternative to pretrial detention. In other places, in other countries, we see the term financial bail being used as an individual alternative to pretrial detention, but that's not the meaning that bail has here in this context, in this presentation. Bail is the alternative to pretrial detention, and it may have various conditions applied to it. So who are we in Ireland? And many of you will know us well. We're a common law country, historically influenced by being part of the British Empire. Part of the island received independence in 1922, and there was an original constitution for that new state. It was replaced in 1937 with Bunreacht na hÉireann, the Constitution of Ireland, which contains fundamental rights guarantees specifically in its text, including the right to liberty and the right to trial in due course of law. And those rights have been interpreted in various ways by members of the judiciary subsequently. One important issue to mention is something found in some other places too. We still have a division in our legal profession between barristers and solicitors. Solicitors, it's changing a lot, but primarily solicitors do tend not to advocate in court, whereas barristers do that more regularly. Why that matters in this context is the kind of specific legal culture that exists amongst barristers and how they approach decision-making when it comes to pretrial detention. And one element, which I'll explore in a bit more detail later on, concerns the fact that barristers can act for both the prosecution and the defence. There are no restrictions on them acting for one side or the other. And it's not in any way uncommon to see a barrister acting for different sides in the course of a single hour or a single day in court. Prosecution, there are lots of different prosecuting bodies, but the primary ones are police, the Gardaí, and the Director of Public Prosecutions for things which are more serious. It's also notable that we don't have any specific training or pathway to be a judge. Judges almost overwhelmingly come from legal practice, either solicitors or barristers, but there isn't a judge track that you find in some other countries. It's also notable that we don't have electronic monitoring at the pre-trial stage. It's used very sparingly elsewhere, but we do not use it at the pre-trial stage. So it may be even more remarkable, perhaps, that our rates are quite low when we don't use electronic monitoring. So here we are, and I hope this isn't too horrible to look at, but where we sit in comparative perspective in European terms. So we're towards the bottom of the table, roughly about 15 pretrial detainees per 100,000 inhabitants. That has gone up. When we started the study in 2016, it was about 12.5, 13, so it has crept up, but it's still on the lower end of the European spectrum. Our prison population rate is also on the lower end, but not the lowest. But we certainly are sitting at the more restrained end of use of pretrial detention. But as I say, it is growing. Our own raw figures, the numbers of committals to prison under different headings since 2007, the numbers of committals in general have been falling. There's some indication that post-COVID that those numbers are going up again. The number of sentenced people has been falling. The number of committals under sentence have been falling. And the numbers committed for pretrial detention have been sort of stable, but falling a bit. But our rate is going up. So it certainly seems that our length of pretrial detention is increasing, and part of that, and this is only anecdotal, I'm afraid, but part of that is down to COVID and the delays regarding trials. But also it seems, again, anecdotally, that some of the individuals who are in pretrial detention now are in there for quite serious matters, and the length of time it's taking to prepare cases like that is quite considerable. So pretrial detention rates are going up, and we also have a big shortage of judges. So all very practical reasons for that. And you can see that then in our figures, the average daily prison population rates and the average daily remand detention rates. The 2023 figure is not totally representative because it's taken from a different time point to the others. It's taken from the most recently available figures earlier this week. It may be that averages out and falls down to more normal figures later on, but we can see a drift up in the number of pretrial detainees on any given day in the Irish system. So the culture I'm going to describe does look like it's under some kind of attack at least. So looking at the legal framework, first of all, importantly in our law, there's a prima facie, or on the face of it, right to bail. It's not automatic that a person will be granted bail, but it's viewed within law and within interpretations of law by the judiciary as an important aspect of the right to liberty and the presumption of innocence. So that's kind of a starting point. You have a prima facie right to bail. And how can you be refused bail, or how can you get into pretrial detention? These are grounds which are found in many other countries. Not appearing for trial, absconding or otherwise evading justice, interfering with evidence, and then an important one, a real risk that the accused will commit serious offences if granted bail. And the third one, the real risk of committing serious offences, is a much more recent introduction to the other two, dating from the mid-1990s. And that's the one, if there was one message from this presentation, I think it's this, that when there's an emphasis on risk of committing offences while on bail, you tend to see higher pretrial detention rates. And there isn't such an emphasis on that in Ireland. And I think that is one of the main reasons why we don't have very, very high rates. A really foundational Supreme Court case, and it's still very important and quoted all the time in courts which are dealing with pretrial detention issues, is that of the People Attorney General and O'Callaghan from 1966. And the importance of this case is that the Supreme Court said it was unconstitutional to put a person into pretrial detention on the basis that they are likely to commit offences. The Supreme Court said that was a form of preventive detention and it wasn't allowed under the Irish Constitution. That was a really strong statement. And my archival research has shown that various governments at various times seriously considered a referendum. In order to change our constitution, a referendum is needed. It must go to the people for a vote. And various governments very seriously considered doing that, but nobody actually did it until the 1990s. That was the time where a referendum was introduced and passed to reverse this decision, to allow pretrial detention to be imposed on the basis of a risk of committing offences. But that original basis, or that original grounding for when pretrial detention can be used, really holds very strongly still, and maintained a kind of a real resonance, I think, for legal practitioners and for judges. And the O'Callaghan decision is still very much an important one. That the grounds are really primarily to absconding or interfering with the process. So we did pass legislation, Section 2 of the Bail Act 1997, which allows pretrial detention on the basis of a risk of offending in the case where serious offences are at play. These are common grounds shared across certainly many European countries and more broadly as to reasons why a person is put in detention while awaiting their trial. Section 2 of the Bail Act, the court may refuse, that's the terminology used, bail. So again, the terminology is kind of important. It's not must impose pretrial detention, it's may refuse bail in certain circumstances, and they have to take into account various factors surrounding the offence and the person, including the length of time likely until trial. In 2015, we brought in some legislation around burglary offences. There was sort of a mini scare around burglary at the time, trying to make it more likely that a person would be placed in pretrial detention for burglary. offences, but the impact of that is pretty unclear. So what did we do in our study? Well, in the Irish context specifically, we conducted observations of pretrial detention hearings, which are all public in Ireland, very rare exceptions to that, exceptionally rare exceptions to that. And we had 26 interviews with judges, lawyers, staff of the probation service. And this format was replicated across the 7 countries that are outlined there. We wanted to explore what are the assumptions, the ideas, the beliefs about how pretrial detention should be governed and what influences decision-making practice. We did not do a quantitative study exploring how decision-making works in that way. I think that'd be an amazing study to do. It's not our one. Ours was trying to explore what people think influences their decision-making and how they describe their decision-making. In the case of Ireland and its legal and judicial culture, it's not an exaggeration to say that we discovered a culture which sees bail as a default or norm. And even those initial conversations with colleagues from the other European states about the term bail, that's the term you use, not pretrial detention, was itself quite revealing. And I think it remains true to say that the approach in Ireland to pretrial detention is one where you have to argue a person into it rather than argue them out of it. Now, of course, there are exceptions, but even in really the most serious offences such as murder, it's by no means guaranteed that a person will be placed in pretrial detention. And there's always room for an argument about the use of bail or the use of an alternative. So our legal and judicial culture is something of a barrier or a protective factor against the use of pretrial detention. One of the main elements of it relates to the influence of the risk of offending ground. It's much more limited than you see in the other countries that were part of our study. And I think that's partly because of our history, that for so long, judges and lawyers, it was just the norm that risk of offending was unconstitutional, and that kind of stuck with people, I think. And the constitutional protections for the use of bail have been influential. So the prima facie right to bail is a constitutionally protected right. And I think it has a certain status because of that. And it has influenced how people use pretrial detention. Crucially, this culture is shared across prosecution and defense lawyers and judges. Of course, there are individual exceptions, but we do not see a really strong prosecution type mindset that you might see in some other countries. You don't see a prosecution mindset, which is, detention at all costs. A number of our interview partners commented on the ability of the prosecution to sort of remain flexible and to try to come up with alternatives to the use of detention where that's possible, and it's not always possible. It's also notable that there isn't a really strong nexus or closeness between the prosecution and judges. Even in terms of the design of the courtroom, for example, there's no special elevation for the prosecution that you see in other places, or special closeness between the prosecution and judges. As somebody who practiced in criminal defense for a while myself, I would never say it's completely fair, and the defense are always struggling with resources. But defense participants in our study also agreed that there's not a massive inequality of arms, and that's partly thanks to the use of legal aid, whereby a person can be represented by really the creme de la creme of the legal profession, though I want to emphasize that is under attack and must be protected. So thinking about liberty, how liberty is talked about by the players, the actors in decision-making in Ireland. This sense that the presumption of innocence mattered and liberty mattered were shared amongst all participants, not just defense lawyers. So J stands for judge and prosecution stands for prosecution. So again, just to note that we interviewed barristers who act on behalf of both prosecution and defense, and we categorized them as being prosecution if that was their primary type of work. Judges telling us things like it's a big deal to deprive somebody of their liberty. Prosecution saying that the constitutional presumption in favour of bail is something that the judiciary takes seriously. A very stark comment from Judge 3 here, essentially it starts with the presumption that somebody will get bail. And another judge saying there's a very high presumption in favour of bail in Ireland. There's a very strong constitutional imperative here that you shouldn't be ages in custody unless there's a good reason for it. So this was strongly felt across participants and spontaneously mentioned by them as well. And for all participants, when they were asked what are the main reasons why a person is going to be put in pretrial detention, the primary one, the most salient one, the first one that came out was not showing up for trial. It's really, you know, someone who won't show up even. I think that O'Callaghan, this ground on the basis of absconding or interfering with the process, still the main game in town. Another defence practitioner saying, I haven't seen massive changes even in light of the changes around the bail legislation. And my favourite quote is from this judge who said, I know you said the interview was going to take an hour, but it can be all done in 30 seconds because the be all and end all of bail in Ireland is the O'Callaghan case. It's about turning up for trial. And I think that's very important because as I say later, it's kind of an anchoring for how the whole process operates. So the Irish approach focuses on, will the person turn up for trial? And to decide this, they look at past behaviour, bench warrants. So has the person not shown up before? And if they haven't shown up before, they will have got a bench warrant, an arrest warrant to get them to show up. And this is what judges want to know about. Has the person not turned up for trial before? And if there is a very bad warrant history, then the person is very unlikely to get bail, is likely to be placed in pretrial detention. And this is what weighs most heavily. Has the person displayed a track record of showing up for trial in the past? And even if the offence is, you know, extremely serious, if that record is good, there's a reasonable chance, according to our participants, that the person is going to get bail. That's the number one factor, their previous record of turning up. Other factors include the seriousness of the charge and the length of time until trial, but I think in reality the length of time until trial is not nearly as important as the other two. So the actors, this sense of the importance of liberty and the presumption in favour of bail is shared across all of the actors. And there's a feeling that there's equality between the parties, and also an important sense in which the prosecution operates some kind of self-restraint, isn't trying to get detention in all cases. And consent to bail, where the prosecution agrees to bail, is not uncommon, and prosecution participants were very comfortable with it. And nobody thought this was, you know, unusual or outrageous. Prosecution participants were quite happy to try to agree bail where that is possible. I think another factor is that it's not simply liberty versus detention. The conditions which can be imposed on bail can be quite intrusive, not massive financial guarantees that you see in the States, for example, but still significant. Curfews, mobile phone conditions, turning up to the police station, this sort of thing. So it's not a simple liberty versus detention question. In comparative perspective, and seeing this in relation to the other countries as part of this study, the really important one is the grounds that are used and how important is the risk of offending ground. If that is very important, it seems to shape everything to do with pretrial detention decision making and seems to make people more likely to get put into pretrial detention. And whether everybody sort of agrees that these are the rules of the game, that there's a presumption in favour of bail and there must be a reason to go into custody rather than a reason to be argued out of it, matters too. And whether alternatives are viewed as being credible and realistic matters as well. So bail is really well established as a notion in Ireland. So it has credibility. I mean, you know, we could talk a lot more about whether that's warranted, but it's the alternative. Whereas if you're trying to come up with, you know, a bit of this, some kind of guarantee, some sort of restriction, it may not be so viewed as so credible as the really strong alternative that is bail. This concept of not emphasising risk of offending is shared with England and Wales. And this idea of arguing the person in rather than arguing out is something we see not only in Ireland, but actually also in Germany, which, if you remember the comparative slide, their rates are very similar to ours. And in Germany, we see more of an emphasis on risk of absconding as opposed to risk of offending. Really strong emphasis on risk of offending in the Netherlands, Austria, and Belgium. And that seems to be something which influences the legal culture and therefore the use of detention. How has this happened in Ireland? How is this culture being created? The legal framework really does matter. The timing, that sort of maybe serendipitous intervention by the Supreme Court in the 1960s, delaying the implementation of a risk of offending ground, and a historical aversion as a result of that case to a risk of offending, has maybe insulated how the impact of it. The actors matter, defense and prosecution. There's no big distinction between them in terms of prominence or importance. And there is a shared sense of what the grounds are and what the tolerance limits for detention are. And the prosecution isn't going around trying to put everybody into detention without wanting to be flippant. There's a shared sense of the right way to do this, for the most part, amongst all of the participants. And I think how this matters for other places, it really boils down to the question of how is the pretrial phase seen? What's the point of it? Are your interventions to secure the proceedings, so to make sure the trial goes ahead, or is your objective to prevent offending? And if your objective is to prevent offending, then you're changing the mood music, you're changing the tone of the proceedings completely. If your objective is to make sure the person is turning up for trial, I think a little bit of space opens up in which alternatives can be used. And it's also important to emphasize this shared set of understandings about liberty and the presumption in favor of bail between prosecution and defense, because that has not been seen in the other countries that were part of our study. And that kind of shared experience of their legal training, many shared experiences in their practice of the law, and then judges who have come from both prosecution and defense, or even, no criminal law background at all. This shared sense of what the rules are seems to permeate all of the actors and is important. Now, as I mentioned, our rates are increasing, and we do see some evidence of the prosecution self-restraint being eroded, and that there is more of an emphasis on the use of pretrial detention, but it still hasn't been enough to push us very high up the European league yet. So overall, the importance of the legal framework is something to emphasize, but the primary factor, I think, in Ireland, and also seen in comparative perspective, is this emphasis on securing the proceedings rather than preventing offending. And that anchors the whole approach to pretrial decision making. And with that, I'll conclude and say thanks for your attention.